All right, good morning, everyone. Thank you so much for taking the time to join us. We're so excited to have you with us and excited to get to share a little bit more with you today about the California Attorney General's enforcement action last week and the implications it has on the privacy landscape. I am Sean Lichty. I work in product marketing here at Transcend. And I'm just so happy to be able to host today and get to share our incredible presenters with you. Before we get started, I am just going to give a general reminder that we're going to be providing some general background about regulatory issues. This is, of course, for informational purposes only. This is not legal advice. You should, of course, consult with your own legal counsel on specific legal challenges or questions that you're facing. But we are happy to provide this overall guidance and kind of some background and context for you today. Today, we will be hearing from some awesome fellow Transcend employees. With us today is Brandon. Brandon has nearly a decade of experience in the technology sector. Most recently, before he came and joined us, he was Associate General Counsel of Privacy and Product for Segment. And of course, it was acquired by Twilio, and so he was with them as well. We are so lucky to have him and super excited for him to be sharing his wisdom with us today. And then we're also joined by Ben. Ben Brook is our CEO and co-founder of Transcend. So we're going to get right into it today. We're going to try to pack a lot into this 30-minute session and kind of maximize what you guys get out of it. We're going to go over the AG settlement action last week, the $1.2 million penalty against Sephora, and take a look at what this means for future CCPA enforcement, as this is the first kind of significant enforcement action we've seen. And then we're also going to get into translating the legal requirements around the global privacy control, or the GPC signal that was kind of at the heart of this specific enforcement action, and take a look at what it means to have a compliant tech stack for do not sell, do not share, as California and of course other states as well continue to roll out requirements in this area. So with that, I will hand it over to Brandon for the first portion of our webinar.
Thank you very much, Sean. Thank you everyone for joining today. Really happy to be here to talk about this. Definitely interesting times in California from a privacy perspective. So just by way of background, so Sephora settled last week and this enforcement action was announced with the AG's office for $1.2 million for alleged violations of CCPA. And the Attorney General had alleged that Sephora was selling data to third parties, and not disclosing in their privacy notice that they were engaged in this selling, and then not honoring requests of users, consumers, to opt out of the sale of data, including also specifically not honoring the global privacy control signal from browsers. So this is the first enforcement action under CCPA that we've seen that has resulted in this monetary settlements. And so for me, I think there's three big takeaways. I'll list them out and then we'll dive in a little bit more detail into each of them. So the first, I think, is that this enforcement action makes it really clear that businesses must honor the global privacy control signal to opt consumers out of the sale of data, as they would honor any other valid request to opt out of the sale of data. Second is that in the Attorney General's view, use of third-party trackers on your website almost always constitutes a sale of data, with some caveats and exceptions, and we'll dig into those a little bit. And then I think the third big takeaway for me is that in this enforcement sweep that the Attorney General undertook, they identified many businesses that they viewed were out of compliance. And I think there is a lot to take away from that, many of us, if we go and look at our websites, our consumer-facing sites, may be technically out of compliance with CCPA in the Attorney General's eyes. So Sean, if we want to go back to the first slide, we'll dig into global privacy control signals a little bit. So we see from the settlement documents and the complaint documents that when the Attorney General initiated this enforcement sweep, global privacy control signals, which are these technical signals that users can emit from their browser by installing a plugin, They were kind of at the core of the Attorney General's investigation. So what the Attorney General's office was doing was going website by website to these consumer-facing brands and checking the network traffic that was emitted from these sites to see whether it changed when they were using the global privacy control signal and when they weren't. And in Sephora's case, they noticed that there was no change. And so they did further testing and came to the conclusion that Sephora was not honoring this signal, despite the fact that they were sharing information with third-party trackers that were on the site. So for those who have not sort of tracked the requirements around universal opt-out signals or the global privacy control signal in California, just by way of background, the CCPA statute itself doesn't mention anything about universal opt-outs or global privacy control. But it does give the Attorney General the authority to promulgate regulations designed to further the purposes of CCPA. And so in the initial set of regulations, the Attorney General issued regs that said that if a business collects personal information from consumers online, the business shall treat user-enabled global privacy controls, such as a browser plugin or privacy setting, as a valid CCPA request mechanism. There are some who have argued that that regulation extends beyond what CCPA would allow. But even in that regulation, it did not specifically call out global privacy control, which is a specific standard, as the sort of anointed standard of what the Attorney General believes that we should be doing. But then in 2021, the Attorney General tweeted specifically support for global privacy control, updated their FAQ page to indicate that they would be treating global privacy control as a requirement, that businesses with consumer-facing sites needed to honor that signal and opt folks out of the sale of data when they detected that signal. And so I think this enforcement action puts into perspective that none of this was fluff or hyperbole in any way, that the Attorney General was really serious about enforcing the requirement that businesses honor global privacy control. Sort of looking forward in the regs and statutes, so under CPRA, the statutory text says that the CPPA, the body that is given the authority to create regulations under CPRA, has the authority to come up with some rules around a universal opt-out signal. But the statute itself is probably not super clear on whether that's mandatory or optional. But in the draft regs that have come out so far, we see that the CPPA takes the same view as the Attorney General. And in those regs, those draft regs, they make it clear that honoring universal opt-out signals is a mandatory requirement. Other laws that are coming out, so Colorado, for example, as well as the proposed federal bill, both make references to universal opt-out signals. In Colorado, that law says that businesses must honor that a universal opt-out signal by 2024. And it's that state Attorney General's responsibility to come up with a technical specification that's acceptable for that purpose. And then the federal law does something similar where they grant the FTC authority to adopt a universal opt-out standard as well. So I think the upshot from all of this is that the Attorney General in California views GPC as a requirement, and businesses should look really critically at adopting the technology to be able to detect and then honor downstream global privacy control signals and opt users out of the sale of data in that scenario. Advance the slide to the next. But I think that the second big takeaway is that in the AG's office, use of a lot of third-party trackers will constitute a sale of data. And in the Sephora action in particular, The settlement and the complaint documents mention that Sephora was allegedly using a popular analytics provider. It doesn't go into specifics on what that is. Some folks have assumed that it's Google Analytics or something similar. But the theory that the Attorney General put forward here is that sharing personal information with this type of analytics tracker constituted a sale because Sephora received, in exchange for that personal information, analytics services. And this is sort of a tricky, mushy area in the law, because I think many folks would view this type of relationship where you receive a service in exchange for personal information really as a service provider type of relationship, where you're actually obtaining an analytics service from this third-party tool on your own behalf and not exchanging data for the analytics benefit. But what the Sephora documents show is that the Attorney General's sort of core complaint here was that Sephora didn't have sufficient service provider contracts in place with these third parties. And so I think the takeaway from this point is really that you should look very critically at any third-party trackers that you're using. And if you've done the analysis and you think that this exchange of information with a third party is truly a service provider relationship and meets that definition under the law, you need to make sure you've checked all the boxes to formalize that relationship, including making sure you have service provider agreements in place with those third parties. And then moving on to the sort of last big takeaway, and I think this struck a lot of folks, is that the Attorney General's enforcement sweep here touched on a lot of businesses. They indicated in their press release last week that over 100 businesses were in this initial sweep and got non-compliance letters from the Attorney General's office. And then the Attorney General said that they are sending out a series of additional letters now as well. Most of the businesses that got letters did not end up in Sephora's position, because all of these businesses were given 30 days to cure their deficiencies, as they're entitled to do under CCPA. Sephora did not, and so that led into this further action and ultimately the settlement. It's worth noting that moving forward next year under CPRA, that 30-day cure period is no longer mandatory. It becomes discretionary as enforcement moves from the AG's office to the CPPA. That 30-day cure period is discretionary as far as the CPPA is concerned. And so it may be the case that they do not allow businesses a chance to cure these types of deficiencies going forward. And they may think that at this point, businesses have had several years now to comply. And so the chance to cure is just going to disappear. Worth keeping that in mind as we sort of review public-facing privacy compliance controls on our sites, and making sure that things that are very obvious and visible to consumers and to regulators are buttoned up and in compliance moving forward. I'll also just mention, one commentator pointed out, it is very interesting that the first major enforcement action out of CCPA did not go after, one of the big tech companies. I think we're very familiar under GDPR with the data protection authorities there, hitting big tech in Silicon Valley. The Attorney General's office is really focused on consumer-facing brands. And Sephora happens to be, a French-owned company, which is interesting in sort of an ironic way. But consumer-facing brands that interact with a lot of personal information are what the Attorney General is most focused on now. So if you fall into that category, I think be aware that the Attorney General is monitoring this sort of stuff very closely. Um, and then I guess the last point I'll make, if you want to advance the slide, is that as folks are looking at ensuring that their sites and their businesses are meeting CCPA compliance standards, thinking about what the Attorney General is focused on is a good way to come up with a checklist and go through that that gap analysis in that process. And the Attorney General publishes on their sites a list of example enforcement letters that they have sent out, and then the steps that the responding businesses took to cure those deficiencies and remediate those deficiencies. I think we're going to send out the link to this for folks who want to go visit this. Last week, the Attorney General updated this page to include examples of businesses who did not honor global privacy control signals, and then the steps that those businesses took to cure that deficiency and avoid the sort of Sephora settlement that ended up coming out. So I think it's worth using these examples as a good roadmap for how to make sure that you're mitigating risk at your business and buttoning up privacy compliance. And Sean, we'll kick it back to you.
Awesome. Thank you so much, Brandon. There's so much great context there. And I love the point you make about how it's really interesting that this wasn't a big tech company like so many assumed some of the first enforcement actions would be. So now that we have that context and we've got that background on the Attorney General's action and the legal thinking going on here with the regs, let's pivot over to Ben. Ben, do you want to give us some additional color on how compliance actually works from a tech standpoint and what it actually takes to detect, honor, and make sure that there's complete fulfillment of opt-out requests happening?
Yeah, absolutely. Thanks, Sean, and hi, everyone. It's great to see you all today. So just to give a quick bit of background here, the GPC was formed in response to the CCPA requirement for businesses to honor a browser-based signal as a do not sell opt-out choice. And so this was created by some folks in the privacy community, including Robin Bergeon, Sebastian Zimic, and other folks from places like DuckDuckGo and the Brave browser. And this is a browser specification where either the browser itself or an extension added to a browser can actually create this signal for any user visiting a website. So they can signal to the website that they have enabled this GPC flag for themselves. And that website is then required to detect that signal and honor it as a do not sell or share request. And so the easy part is actually detecting GPC. This is a relatively simple implementation on your front end code. It's really only a couple of lines to see whether or not a user has GPC enabled. And that is in the global privacy control.org spec. It's very simple to actually see how to honor or to detect the signal. But the harder part is actually honoring it as a do not sell or share request. So how do you actually implement that downstream to actually change the way that you're collecting and using this individual's data? These processes that constitute selling or sharing almost always are fully automated pipelines where data is just being collected in an automated fashion, meaning that to actually implement do not sell or share and honor it, you have to alter these automated pipelines. And so for a lot of businesses, this actually represents a fairly large project of overhauling all of their ad tech integrations, as well as integrations with other vendors that are collecting data from their site and sending it directly to those service providers, those vendors. And so the business is then required to implement a way to essentially halt those automated pipelines for the individual users who have opted out, whether they have signaled GPC or they've explicitly opted out through another mechanism. And this is actually getting more complex day by day because there's now a rise of special APIs as well for do not sell or share with these ad tech vendors. So for example, Google restricted data processing, Facebook limited data use parameter, YouTube privacy enhanced mode. And this actually requires modifying the events that you're collecting on these individuals and sending them to these services downstream. And so these events actually have to be modified right on the client-side website before they get emitted to these third parties. And these special APIs were actually specifically called out as an implementation requirement in that Sephora settlement. So Sephora actually has to implement these new APIs, and these are sort of changing every day. So it's becoming an increasingly complex technical implementation. And so now, essentially, for businesses, they need to either look at a third party that can help them implement this to actually encode these changes as a result of a GPC signal or an opt-out. And these vendors or third parties will have to essentially be able to halt pipelines to vendors that are automatically receiving data from your website or implement these special APIs and modify events that are being captured by your website and being sent to these vendors. So for the Transcend consent customers in the audience today, just know that you're already covered here. Transcend consent has always detected GPC and treated it as an opt-out. It's also integrated with these special APIs like Google restricted data processing, Facebook LDU, and more. And for anyone who's not yet using Transcend consent, of course, we'd love to talk to you and see if there's a fit. But if not, the way to approach this problem is really by looking at each of your third parties that you're sending data to. And if they don't meet that service provider definition under the AG's interpretation, then you're going to have to actually modify the way that your ad tech stack works. And so there's more to peel back with probably your engineering team there. But you know, if anybody's looking to sort of get a little bit more deep into a consultation on that, we're more than happy to follow up. And so, our contact info will be here at the end.
That's awesome. Fantastic background. Ben, could you talk a second about the differences between, you know, some people are maybe saying, oh, well, we have, you know, we have a cookie banner set up, we have cookie compliance set up. Isn't it enough to just let people manage the cookies that we're setting on our site? What is the difference between a compliance solution like that versus more of a do not share or do not sell setup?
Yeah, well, so there's a few components there. So the first big one is that a lot of these ad tech vendors have these special APIs where you have to actually modify events. And so it's actually better to think of this problem as more of a data flow rather than just a dropping of cookies. And so how do you actually regulate data before it's emitted from a user's device to any sort of third-party system? So the way we've approached the problem is to sort of think of cookies as like one tiny component of the sort of tracking stack, but really generalize all of it into like what data is being emitted from the user's device to any of your systems or third parties, and how do you actually regulate those data flows. And so the way we approach the problem is actually by thinking of it as how do we actually put like a firewall in between the user's browser and all of these third-party destinations such that anytime data will be emitted, it has to pass through a rule engine in this firewall. And so cookies are like one tiny example, but there's also Facebook Pixel, there's, you know, Navigator.SendBeacon, there's all these different technologies that are collecting data, but they all sort of land in this class of like what data is being emitted from my device to anything out on the internet. And so we really take the sort of like most base truth, which is what are the data flows that we need to either halt or modify to fit with these new special APIs. So it's a very fundamentally different problem than cookies. And even under GDPR, it's not just cookies. So cookies is sort of a misnomer in the industry, I think, and really it's about all data that's being collected and processed. And so if you're only looking at cookies, you're probably only looking at a very small piece of the pie in terms of what you're collecting.
Yeah, absolutely. That's awesome. And I know that we've had conversations where you know, our customers have said, you know, look, we're not particularly concerned with GDPR right now. That's not a regime that we're currently required to comply with. And so it's great to be able to have kind of the lower friction from a site standpoint setup of not having to have like an immediate launch banner on the homepage, or you know, there's additional flexibility basically with the footer links and just more of a streamlined do not sell share approach, which is really helpful. Ben, can you talk a little bit about, especially for anyone in the audience who maybe has a little bit of a more complicated data selling or sharing stack that goes beyond just client side data collection? Obviously, probably the majority happens from tracking pixels from ad tech, but there's definitely other ways to sell or share data. You know, CDPs like Segment can be a part of that. For those sorts of a situation, what additional considerations do they need to be thinking about as they think about complying with an opt-out request, whether it's via GPC or another method?
Yeah, so this is really where we start getting into a broader privacy infrastructure. So of course, as Sean correctly said, you know, oftentimes selling and sharing is not just something that's happening from your website, but there may also be back-end based processes that are transferring data from perhaps your application database out to the Facebook lookalike audiences or something like that. And then there's also oftentimes even manual, just people in the marketing team, for example, by hand are exporting and uploading CSVs of user data into these platforms for the purpose of targeted advertising. And so not only do you have to be able to regulate this on the client side, you know, on your website with a consent technology, but also you have to have a stored record of consent for the individuals who have opted out. And then you have to integrate that into backend systems as well. So you mentioned Segment as sort of a CDP that sits on your backend, it receives events, and then it sort of disperses those events to other systems on a backend based process. For something like that, you need, again, an integration with special APIs into this, but it's backend based. And so, for example, in Transcend's privacy infrastructure, we'll be adding those users into a suppression list on Segment such that they can't flow to those downstream vendors. But that really generalizes to really any backend based flow where either there's a third-party vendor that's doing it and has some sort of API that Transcend is already integrated with to encode that user into a suppression list, or it's a homegrown pipeline that the engineering team has built where there is some process in a company's own code base that is transferring that data out. And in that case, we can integrate directly with that code base using like SDKs and APIs to basically help that code understand who has opted out and who to conditionally send that data to, and who to conditionally, you know, suppress that transfer of data. And then, of course, for that third use case, which is the more manual export and upload process, we also have a way of essentially diffing out all the users who have opted out to make sure that they get they don't have their data sort of sold or shared in spite of their preference.
Yep, awesome. Well, as you all can tell, I'm sure there's a lot of nuance as you start to unpack and zoom into some of what's happening. And let me tell you, as someone who's spent some time in the draft regs for what the regulators are looking at with CPRA, unfortunately, it's only getting more complex from here. But the good news is that you don't just have to get it all from a 30-minute webinar. We have some pretty extensive resources. We actually recently had a great post on demystifying dark patterns and working through what the regulators are thinking there. We have a very in-depth implementation guide that goes over more of what Brandon and Ben just covered, helps you think through how to map out your data inventory inside your org to understand what sale or sharing you're doing, and then what kind of compliance steps you need to take. Brandon had a great blog post recently about things you can do now to start preparing for CPRA next year. All of these resources we'll be following up with. We hope that you guys found this really helpful. And as always, please feel free to reach out to us directly if you have any questions or would like to better explore what compliance may look like for your org. But thanks so much for joining today, and we hope you all have a great rest of your day.
Thanks, everybody.
Thanks a lot. Have a good one.